Strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the Ask the Expert Show with local celebrity hosts Steve-O and Renee. Sit back each week while Steve-O and Renee educate you with live in-studio experts, such as lawyers, doctors, home improvement, and financial experts in their field. Call in and have your questions answered each week at 888-565-1470. Now, here is Steve-O and Renee with today's expert in their field.
Good afternoon and welcome to another Ask the Expert show where we bring you the top experts in the areas of legal, health, financial, and home improvement. My name is Steve-O and I'm here live in studio today with my co-host, Renee.
How you doing? No mic.
No mic. We're not used to that, so we're just going to put this here in the middle. Today, if you'd like to watch today's show, you can go to www.kbasandboyrlegal.com and you can click on the News PR link at the top of their page. Voila, you can watch today's show live. We have live in studio some really good friends of the show. This show has done so great. We've gotten so much
huge
response on thanking us for doing a show like this.
Yes.
The show was extended to an hour.
Right.
So let's welcome the law firm, the top, they can't say this, we can, the top community association law firm in not just South Florida, but throughout Florida, Kaye, Bender, Rembaum, which I don't even have to look at anymore. We have Robert Kaye and Michael Bender on our show, live in studio.
Thank you.
Thank you.
And we're so glad to have you guys on today.
Yes, if you'd like to call, if you have a question, call us at 888-565-1470 for either Michael or Robert. And like Steve-O said, we get so many emails thanking us that we have a show like that, and we've seen it because we've had so many phone calls. People have so many questions concerning HOA and condo law. So tell everybody a little bit about your firm.
Well, the firm has been practicing in this area of law since 1991. Some of our participants have been doing it longer, but the firm itself has been doing it since 1991. And we represent all aspects of community association legal needs, from interpreting documents, preparing demand letters, filing liens and foreclosures, negotiating contracts, all aspects of day-to-day association operations.
And where are your offices located?
We have an office located in Pompano Beach, which is our main address, and Palm Beach Gardens is our second office.
So you cover Broward and you cover Palm Beach. Do you cover Dade as well?
Cover Miami-Dade as well. We cover Martin County, Monroe County.
Collier.
You cover it all.
Well, not it all, but close.
You know, we got a tip because we had so many emails. We have to give everybody the phone number here if they'd like to call in. If you are a board member, if you are a property management company, what have I left out? You want to watch today's show. If you have a question, call us at 888-565-1470. That's 888-565-1470. And both Robert and Michael will field calls. I love doing this show because we have the biggest, the best. How many clients do you have now? Around 800?
Well, the firm represents a bit over 800 communities, yes.
That's a lot. See, that's why all those other law firms are starving. They got all the good properties. You have so many things coming up.
We do.
So let's get started.
Okay. Well, one of the things, in addition to obviously the representation of our community association clients, our firm is very big on education. And we've been offering education in our offices in both Palm Beach Gardens and Pompano for years. And we continue to do that. And you can visit our website at www.kbrlegal.com. And you can look at the seminar schedules, and you can get the schedules for both locations. But coming up this week, starting this week, we have our 7th annual Town Hall Seminar Series, which we're very excited about. Something that Robert and I, have, on behalf of the firm, have been going out and doing for the past 7 years, where we go to 7 or 8 different locations throughout the Tri-County area, and we offer a couple of hours of
For free.
free legal advice on topics that are basically set by the attendees. We encourage people who are looking to attend to RSVP in advance, and they can do so at our first seminar is going to the first town hall
Is it on
seminar will be
Tamarack?
in Tamarack on
And that's
this
November
Wednesday.
5th.
Wednesday, November 5th from 6:30 to 8:30 p.m. at the Tamarack Community Center, 8601 West Commercial Boulevard. And the phone number to RSVP for that is 954-776-1999, extension 255. They can also send an email to our office through our website at info@kbrlegal.com. And we encourage, if you're going to RSVP either by phone or email, to give us this question or topic that you'd like to be discussed at the seminar.
And
Maybe,
it's a question and answer format.
The entire, right. So
and we already have our first phone call.
well, let's
Let's
take that call.
take our first call.
Sure.
Hey, Mark. Mark.
Hello.
Hey, Mark.
You have a question for one of our attorneys?
Yes, I do.
You've got Robert and you've got Michael here from Kaye Rembaum. What's your question?
My question is, they have an association, homeowner association, that has a clubhouse, and in the clubhouse they put on shows to the residents for which they sell tickets. So they want to put on some shows that, let's say in any given year, they put on several shows that might cost, let's say $50,000 for all the shows. But of course, they can't sell tickets to everybody in the community because the clubhouse is not large enough to get everybody in. So they're limited on number of seats they can sell. So in order to cover the cost of those shows, they might have to charge the homeowners about $50 a ticket. But they don't want to charge the homeowners $50 a ticket. They want to charge more like $30 a ticket. And the way they want to finance the $20 difference, which winds up being kind of excess cost of the shows, is by having an assessment and charging all of the homeowners in the community to some portion of that of the cost of those shows, even though those homeowners are not going to be attending those shows. So my question is, does an association have the right to assess homeowners for the cost of an event like this when a large percentage of the community is not even going to be in attendance, but yet they'll be paying because the association doesn't want to charge enough money to cover the cost of the shows?
Well, Mark, that's a very complicated issue that you've expressed, and thank you for calling and asking. Generally speaking, in order for the association to finance entertainment of the nature you've described, the governing documents for your community will need to contain certain authority in that respect. Florida law limits associations' ability to make expenditures to those that are specifically set forth in the governing documents. And when I say governing documents, primarily I'm talking about your declaration, and I'm assuming it's a condominium, so declaration
HOA.
of... Oh, it's an HOA.
actually,
Okay, so declaration of covenants will identify whether the association has the ability to make expenditures of the nature you've described.
Okay.
So without seeing them, it's difficult for us to tell you yes or no. So a little further research is going to be needed. You can look at the declaration. You can also look in the Articles of Incorporation and bylaws of the association to see whether the authority of the association to make expenditures for recreational purposes of the membership exists. And from your question, I gather that these shows are only going to be made available to the residents, not outside the community, correct?
No, actually, outsiders do attend these shows as well.
All right. Well, you indicated seating was limited, so I guess it would then be based more upon the interest of the people whether or not to come. And are they going to be charging the same price to outsiders as well as the residents?
That's been the practice thus far.
Okay. And is this a program that's been going on for a number of years?
It has been going on for a number of years. In the early days, when the shows were kind of put together, the objective of the shows was to break even, sell enough tickets to cover the costs. And recently, the board of directors has decided to put a line item in the budget to subsidize these shows because they expect to lose money. They realize they can't make enough because they can't sell enough tickets or sell enough tickets at a high enough price. So for a couple of years, the amount of money was modest, but the dollars are starting to climb. And it's gotten to the point where somebody really needs to question whether or not the association really has the authority to make people who don't go to the shows subsidize, in effect, the cost of those shows for the people who do go.
Okay,
Well,
Mark,
understandable.
great question.
So it's going to be necessary for you to have an attorney, if you know of one, to review the documents. If you're not familiar enough with the nuances, they can be very detailed and give you an opinion as to whether or not the association authority extends to subsidizing the shows.
But you would agree that unless the documents have language to that effect, then it would be improper for the association to do that.
From the way you've described it, yes.
All right, thanks for calling in, Mark.
Okay, thank you.
So if you have a question, call us at 888-565-1470. We have the best in studio today. What are some of the common issues that you see that faces the associations?
The most common issues you're still facing.
This wasn't common.
This one isn't as common, although
not uncommon.
But it's not uncommon to get questions regarding clubhouse usage. Again, a lot of times we'll get subject matter questions, which to some extent we've touched upon in one form or another. Clubhouse usage,
Or any type of assessment.
and certainly assessment-related questions. Yes, and so you have issues, of course, with collection still remains a hot topic, more so with the banks and how can we move the banks along, bankruptcy related questions
Or foreclosure.
Foreclosures, yes, but again, association foreclosures always remains a hot topic, but with the improvement in the economy, we're starting to see a little bit less of that being a major issue for most communities. There are still some that it is, but most communities, they are able to have it more under control. Hopefully,
Well, that's good to hear.
It is, which enables them hopefully to have more operating funds and resources to address the other issues in their communities. Reviewing and amending and updating documents is something that we've been getting a lot of questions about. It's something we have done for years and have helped a lot of our clients out with. Support animals, as we've talked about in the past, that certainly remains a very big issue. And as you know, we offer a course each month in both the Palm Beach Garden and Pompano offices on fair housing and support animals.
We're going to talk about pets in a second.
Yes, we
will.
There's also another topic that affects homeowner associations primarily, and that involves those that are nearing 30 years in age. And there is a technical statutory provision that will invalidate documents if they're not, in essence, recertified by the board prior to the expiration of the 30-year time period. And many communities that were created in the 80s and into the early 90s are facing that type of issue, and they need to be diligent on it.
Very diligent. That's really an excellent point. For those who are listening in an HOA, it's called the Marketable Record Title Act, or MARTA, and as a short acronym. And I encourage you to contact your association counsel to ascertain whether you are in a situation where you need to undertake, as Robert said, the recertification or renewal of your declaration of covenants. And this is a very important issue that Robert brings up, because if you do it within a 30-year time frame of the recording of the original declaration, and that's a simplified version of this, it's a very simple board action. The board of directors can call a meeting and take action to renew or recertify. If it passes the 30-year point, the documents are at risk of actually expiring, and then you have to go through a process which has been created by statute called revitalization, which is a much more extensive process which requires a lot more documentation.
And more costly,
A
of
lot
course.
more documentation
Yeah.
to
A
be
lot more
done, a
cost.
lot more cost. It has to go up to the state for certification.
And a vote of
And a
homeowners.
vote, and most importantly, you need a vote of the membership then. So that's a good one, Robert.
I want to add something. One of the good things about our show is we do all the legwork for you. so you don't have to start Googling somebody. We bring in the top firms, and it seems like there's so much new information happening all the time, and I'm sure that's why you do your seminars.
Yes.
Today, I know for a fact we have a lot of new people listening to the show today. Tell people why they should retain your firm. Because I'm going to say something. There's a lot of these firms that hang the shingle up. We do community association.
Sure.
They just do that on a part-time basis, basically. This is all you do.
It is what we do. I would say the large percentage of our representation is of community associations. We are a corporate council and most of our corporate clients happen to be community associations. It's something that board members don't always recognize. When they volunteer and join a board of directors, they actually are governing a corporation. It's their community, it's their homes, it's their friends, it's their neighbors, but they're sitting in governance over the operations of, in some cases, very, very large business operations. But regardless of the size, we do come to the table with a wealth of experience in all aspects of community association representation. And what we add to that is something that Robert, Jeff, and I all pride ourselves on, which is the customer service aspect. As association counsel, when we bring the experience, but it's important. There are others, of course, who have similar experience, perhaps. But it's what is important to know is when you need your counsel, that they are accessible, they are responsive, and they're able to provide you opinions in English, so that
That's always helpful.
You're able to understand
in
and follow
plain
them.
English.
And this is an important asset that I think that we bring to the firm. When you retain the firm, you do have the assets of the entire firm behind you. And I think that's a great combination. And we are, I guess, as I was mentioning earlier, we do pride ourselves also on the education aspect, which is something that we give back to the community at large, if you will, the community association community, by offering these town hall seminars. The one we were mentioning before the caller was the Tamarack Seminar, which is our first one this year on Wednesday, November 5th at the Tamarack Community Center from 6:30 to 8:30 p.m.
Which is right on commercial.
Right. These are all of our seminars are free. They are free to all attendees, and we encourage you to come on out, have your questions answered, or listen to the bevy of other questions that get asked. That's the great thing about these town hall seminars is no two generally are going to be completely alike. There are going to be different attendees, people who will ask different questions, and so, as I mentioned, support animals will likely come up each time. Foreclosures will come up. How do we deal with unauthorized occupants? That's another hot topic. But then there's also going to be a litany of other questions. And so right now we have Tamarack on November 5th, and we have a Pompano Beach Town Hall setting on December 10th. That's in the morning, 9:30 to 11:30 at the Emma Lou Olson Civic Center. We will be having then 2 or 3 more in January, February, and March. All of these dates, times, locations are on our website.
That's your website.
kbrlegal.com. You've taught me well.
Love your website, by the way.
kbrlegal.com. And we are encouraged to please go to the website and check out all of the education, the board member certifications that we do each month in both offices, the support animal classes, and these town hall seminars.
And it's a requirement to be certified. Is that correct?
It is a requirement to have certification, yes. You can
You know what? We got to go to break, and we come back. We have more HOA, Homeowner Association, legal talk with two of the finest. The only one we're missing is Rembaum, right?
Rembaum, yes.
That's the only one. So we'll be right back with Michael and Robert. We'll be back in a minute.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we're back. We're here live in studio. If you have a question for attorneys Robert Kaye, did I get that backwards?
No, you got
Michael
it right.
Bender.
You got it.
You got it.
You can call us at 888-565-1470. That's 888-565-1470. Any questions up, we'll be more than happy to answer your questions. And let's get back in just a little bit about the town hall meeting. This is your 7th year.
It is.
It's free. Who should attend a meeting like this, a seminar like this?
Well, I think the seminar is obviously very beneficial to board members, to property managers. We get some people who are in other aspects of the community association field, people who are into bankers or accountants, people in the insurance industry who
Property
come out.
managers.
Yes, property managers, board members, and community leaders. People who either serve or are interested in serving on their board, perhaps as well.
We actually had a mold and mildew, an email, a guy who does mold and mildew, and another guy who does roofing, want to know if they could come to this seminar. Why would they want to come to a seminar like that?
Primarily to meet people that could use their services, no doubt.
Okay.
But they could learn as well.
Okay. Well, these people both said they do a lot with not associations, with condos.
Yes.
So, yes.
Well, it's hard to find a place to live in Florida that is not associated with one of these types of organizations. So having that information available to you is going to be important in your daily life here.
So tell us again what the topics are that you'll be discussing at the town hall meetings.
Well, we don't actually know the topics at
Right,
this
it's
point.
question answer format.
It's a
But what's the
Q&A.
typical? I know the service animals is a big topic.
Right. But like I said, a lot of the questions when I've been going out and to meet with groups, either prospective clients or even client groups, or just attending different organizations like the Broward Coalition, who we work with a lot. A lot of the questions are talking about how do we address these unauthorized occupants. That seems to be a big issue, and covenant enforcement in
People
general.
that are renting.
People who
condos.
who are
Squatters.
It's
Squatters,
primarily
yes.
in the condominium setting, but it also occurs in the HOA setting as well, where individuals are supposed to be screened and approved to reside there, but the owners are not undertaking that process. A lot of times owners might have abandoned the property, quote unquote, and so they have no concern about any of the rules and regulations of the community, and they'll put an individual or individuals in. Also, though, sometimes these are owners who are active, meaning they haven't abandoned the property, but they have put people in, and they're claiming that these are relatives of theirs or friends of theirs.
So
They're
what
not
do you
renting.
do in these different cases?
Well,
How do you handle that?
there's case by case approach, of course, with fact situations. But one of the things that we look at most is you have to start with your governing documents, and what type of enforcement authority do your governing documents provide to a board to address these types of community issues.
It's also important to know whether the board has uniformly enforced these same restrictions across the board to everybody, because the law doesn't allow you to pick and choose who you're going to apply the rules to. They apply to everyone, and if you don't apply them to everyone, then you're not able to apply them to anyone. So
Right,
we
we
talk-
know it's very
so
hard
we-
to evict anybody, to throw somebody out.
And then
It's
we
difficult.
also can assist associations in how to fix that problem when they haven't been enforcing their documents, how they can, again, resurrect these restrictions and be able to enforce them again.
And,
What about,
what I was getting to before that was also when you look at the documents, you want to be looking at how you can address guest restrictions, because that's one of the biggest issues that people will claim is, hey, these are our guests. They're not paying us any rent, they're guests. Well, then in your documents, you want to address guest restrictions so that you have the possibility of addressing that if someone's going to be a long-term guest, well, then now they have to be considered. They have to be treated as if they were actually a tenant residing in the community with the requirement of being screened and approved by the board. That language, though, all has to be set forth in the documents, which goes back to what we talked about. looking at your documents, making sure maybe bringing them, updating them a lot, and addressing these things. Because when the developer drafted these documents, most often they were not concerned about how the community would live once they sold the property and it was homeowner or unit owner controlled.
You know, we had a question that I sent to your office. I just remembered it about handicap parking. Not enough handicap parking. Do you all get into those areas at all?
We certainly do, but handicap parking in existing communities is one which is not automatic. The ADA does not apply in a residential, the Americans with Disabilities Act, and the Fair Housing does not compel the placement of handicap parking within a residential community. Quite typically, as communities are developed, particularly condominiums, there will be some designation of handicap parking in the site plans, and the cities require them. So once they're there, they're not something that are easily removed or altered. You also have situations where residents may have special needs and make a reasonable request for an accommodation under the fair housing laws to have a special parking for them of a handicapped nature, of the size and configuration, and that may require some alteration of the common elements to accommodate them. These are things that have to be looked at on a case-by-case basis. So handicap parking is a hot issue that does come up quite frequently.
What about security? I noticed that a place that I lived in, Highland Beach, security was only there till 11 o'clock at night. Are there laws within the community that says you have to have a certain amount of community? Or
security is quite typically going to also be one that the documents will address, and if they do not, then it becomes an issue of what's needed to the community based upon experience and whether or not the documents support expenditures of that nature. And then it becomes a business decision of the board as to whether to pay for a guard all night long or to pay for a guard only until a certain hour or on alternate days, and however they work it out.
And where a board wants to be careful is when you have security and you're considering reducing it or eliminating it.
That creates liability.
Right, you'd have to, so you want to know what your documents require, and if it doesn't require, then you're in a situation where you have to certainly make the membership well aware that there's going to be a change or reduction in security.
I was really surprised at this security. The gates came up at 11 o'clock because there's no more security there. Mm-hmm. People have to be able to get in.
What's the point of having security
during
the day? You would think you would need it more so in the evening.
Well, a lot of burglaries happen during the day.
When people aren't home.
I understand that, but a lot of people would rather have the security. I know myself, I'd rather have the security throughout the night.
So you can sleep well.
Exactly.
But in that scenario, Steve, you would think that rather than have the gates up, they would create a key fob or some scanner entry system.
You would think so.
No, they just open the gate.
Yeah, they just left the gate open.
That's probably not the wisest approach, but it's less expensive.
But then you got a place like the Polo Club that not only do they have security, they have security. I mean, it's like a fortress there.
Well, man security 24/7 is very expensive.
Right.
Do residents have any say at all?
Yes, residents have a say as to, number one, who's on the board.
Right.
That's their strongest power of choice. They have the say of whether or not to approve amendments to their governing documents. In condominiums, they have a say in whether or not to waive reserves on an annual basis. They have a say as to whether or not to reduce the financial reporting requirements on an annual basis. Some HOAs have those as well. They do not have a say in the daily operations of the community. That's the purpose of the board of directors.
Well, to clarify, not that they don't have a say, they don't have decision-making power.
Okay.
Correct.
Your board member, the membership is encouraged to attend meetings and be aware of what's ongoing. I've gone to a lot of meetings where owners will show up and say, well, you didn't know anything about this. And then you have the 3 or 4 owners who come to every meeting and they'll stand up and say, this has been talked about for the last 6 meetings. Where have you been?
And it's usually in the minutes, so an owner could look at the minutes.
I was going to ask, the minutes, are they responsible for getting those out to the residents?
The law does not compel associations to distribute minutes and publish them, but they are available to any requesting owner to come in and inspect and get a copy.
Gotcha.
And a lot of communities are doing that, where they're posting minutes on websites or in a newsletter. But again, you want to be careful what you're putting in the minutes when you're publishing it that way.
Right. Minutes are something that aren't supposed to be a transcript. And anyone who's interested in what minutes should entail, they could go to our website at kbrlegal.com, click on the Legal Morsels button, which has topical articles that we periodically put on there. And there's a good article in there within the last several months on what should be in minutes.
And how about assessments? Because I know I owned a house, and every couple of months I was assessed whether it was painting the house. I mean, they make the determination. So how do they decide that, what to assess? There were always assessments.
Well,
You mean special assessments?
Special
At the end
assessments.
of each year, each board is to meet and at a budget meeting, and I'm basically going to give you a summary, but it's essentially each of the board, whether it's an HOA or a condo or even a cooperative, the board meets toward the end of the year at a budget meeting, and they're making a projection as to the true operating expenses of the association for the upcoming year, and so they're anticipating day-to-day operations. If there are special projects involved,
Painting.
right? Well, in painting, whether it's painting or you're in a condominium or
It was a private home.
it was a homeowner association, but
Yes.
the association was responsible for painting all the homes.
Yes. As a matter of fact, you were the attorneys. We discussed that.
Right.
But we
Well,
always got
everything was
assessed.
handled perfectly.
Yes, it was.
and in plain English.
Yes.
Yeah.
Well, painting is something that doesn't happen every year. So
It does. I'm just talking
Right.
about assessments in general.
Well, so
Right.
what will happen there when they're in your case where the association, the HOA had the responsibility for undertaking the painting of the outside of the homes, they could have put funds away on a year-by-year basis. They could have within the budget. They could have added an additional line item for like a painting. We'll call it a reserve, even though in an HOA it may not be a statutory reserve, but a painting fund. And they could have done it that way. Or what they could do is when it's time to paint once every 7 to 10 years, they notify the membership. They get estimates. And then they accept the bid and they do a special meeting, which is a 14-day notice, which has to have specific requirements that they're going to levy a special assessment to the membership to address the painting of the homes, which is a necessary obligation of the board to undertake under your governing documents.
Right. And I have to say that development was kept immaculate.
well, there's also the other side of the coin where there are communities that are sensitive to what their monthly or quarterly assessments are and how that relates to the ability to sell property and the market value of the homes. So there are communities where they will intentionally keep those low, not including everything that might be on a regular recurring basis, and then do special assessments to raise the funds as needed, which is not the technically proper way of doing things. And certainly in a condominium, their statute provides for specific items that have to be included in the budget on an annual basis. We've had situations where the insurance, which is generally a major expenditure in any condominium, was quite high, and the association thought they could be clever by keeping the monthly down by only including a portion of their annual insurance and then doing a special assessment for the difference. And that would be in violation of the statute and the rules of the division of condominium.
And when you sell your home, you're required to let people know that there's assessments.
If there are special assessments that are already adopted by the board, you're required to disclose that. You have no requirement as a seller to disclose what the board is thinking about doing.
No. I'm just saying because I know that I had to tell the buyer
Well,
that
that
there were
becomes an
assessments.
issue of negotiation
No, I
between the
understand that,
parties
yes.
as who's going to pay those.
And remember,
Right.
when you're saying assessments, you have regular assessments, which might be monthly or quarterly, or in some HOAs
Some call
annually,
maintenance.
Maintenance assessments, and then you have special
Had
assessments.
those too, yeah.
Right. So your regular assessments or your maintenance assessments, those are going to be on any estoppel or payoff. Special assessments, as Robert mentioned, only need be added to that if they've been already approved by the board, not only considered.
Okay. We need to go to break, and when we come back, we're going to get into pets. And I also have a question about something the appellate courts altered, collection practices, when we come back. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
Well,
And we're
I
back.
didn't want to lose it.
We are here with one of the top law firms, community association law firms in Florida. They're with us every month. It's Kaye Bender and Rembaum, and we have with us Michael and Robert today. This is a great show. Even if you're not on the board, I mean, this kind of teaches you the ins and outs of what's going on within communities. And so if you have a question, call us at 888-565-1470. That's 888-565-1470. And we've got the best in here. So you'll get a good answer, and you'll be able to understand it, too. So I saw something, actually was on your website, that was where the appellate courts altered their decision after 23 years of collection practices for condominium associations. It just said for condominium only.
This was legal morsel article.
Yes, this was a condominium case. It involved, in 1992, the legislation was changed to provide for an application of payments. When somebody is delinquent and they make a payment, it's going to be applied in a certain manner. And the statute specifically says that any restrictive endorsement that accompanies the payment, such as payment in full or payment for this or payment for that, is irrelevant and not applied. This recent case and the facts that were presented in that case decided the opposite of that. There was a situation where there was a third-party purchaser after a foreclosure situation, and the parties were going back and forth, and the attorney for the defendant in the case sent a very small payment. It was like $30,000 that was owed, sent maybe an $800 payment saying, this is all we owe, payment in full. The attorneys accepted the payment under the expectation that the statute that applied, that restrictive endorsements do not apply, and you just apply it the statutory manner. And the court held in that case that that was not the case. There's another statute that's called accord and satisfaction, when it's clear and unequivocal that this is going to be the payment of a disputed sum and you accept it, then that would be considered a payment in full, and that's what was applied in this case. And that altered the way collections could occur in specific circumstances. It's not an across-the-board holding because of the facts of the case were so specific.
How did it get to the appellate courts, though? How did it get up that high?
Years of litigation.
Wow.
And that's a real good point to reiterate, though. There's been a lot of important decisions like this over the last few years, which could have much more far-reaching effects than they should, only because the facts in the particular case are so specific as to lead it to what a lot of us in community association world find to be a wrong or poor decision. And so that's where one of the things we are working on this year, I serve on a couple of different legislative action committees, and in what we're working on there is trying to amend the statutes to clarify the payment application process and to essentially eliminate the negative effects of this recent appellate case.
Give everybody your phone number again.
800 number is 1-800-974-0680. Direct to Pompano is 954-928-0680. And to Palm Beach Gardens, 561-241-4462. KBRlegal.com. You can always reach us there at info@kbrlegal.com as well.
And you want to talk about additional seminars that you'll be holding?
I did. Thank you. As part of the education series that we are implementing, we continue to enhance and improve on it. And what we're doing in the next next 2-3 weeks is we have a couple of programs that we're proud to be doing with some other very reputable organizations who in our community association industry. The first one is a joint course with Campbell Property Management. John Tite, who works with Campbell, will be co-presenting with Shelley Murray and myself, Kaye Rembaum, on budgets and collection foreclosure process and issues. This is going to, we actually had this course in our office last Wednesday, and it was very successful, and we're repeating it again on Monday, November 10th, from 9 to 11 a.m. at the South County Civic Center. That's in Delray Beach. Okay, that's Monday, November 10th, 9 to 11 a.m. at the South County Civic Center. That's on budgets and foreclosure process and issues, along with...
Or they can go to your website also.
They can absolutely go to our website. And then the second course...
Well, before you go to the second, is an RSVP going to be required?
I'm going to do the RSVP for both.
Oh, okay.
Thank you. The second course is going to be a joint course with Barry Scar of Scar Insurance, who does community association insurance throughout the state. And Barry and I are going to co-present a class on association operations and insurance issues. And so we're going to talk about association operations and tie in the insurance aspect to these operations. It'll be a nice joint course that we're offering. That's going to be at our Pompano office. That's on November 18th. That is a Tuesday, I believe. Tuesday, November 18th, from 6:30 to 8:30 p.m. So both those courses, the November 10th from 9 to 11 at the South County Civic Center in Delray Beach, and the Association Operation and Insurance Issues in our Pompano office on November 18th from 6:30 to 8:30. You can RSVP at our website, info@kbrlegal.com, or you can email Odalis, that's ODALIS, at kbrlegal.com, or call the 800 number, 800-974-0680. Let us know which and when you want to attend.
It is important that one who's interested in attending do RSVP because seating is limited, and we want to be sure that people don't come and have to be turned away because we don't have room for them.
And you have a calendar on your website with all these different seminars, so people could go to your website and sign up there.
They can go to our website, and then they can email us at info@kbrlegal.com. Sure. And by the way, these are both free.
I got to ask you, I mean, you guys have got a very busy life, except our buddy over here just got back from vacation. But what made you decide to put on all these free seminars? I mean, you guys really give a lot back to the community.
Well, I mean, there's no question we get asked. We go out and we do trade shows and we do expos and we go and we meet people, and a lot of people will come up to our tables and they're asking questions, and a lot of times they are the same questions. And then of course we're getting frequently get questions asked by our association clients or prospective clients, and there's no question there's a huge need for education in this arena. The volume of information between the Florida statutes and your governing documents and day-to-day operations, and when you're talking about issues like foreclosures or litigation,
and
court procedures,
frequently.
it does annually, and that's another course we go out. We do the legal update, where we offer it if we have management companies who want their managers to get certified for the legal update. They can contact me at or Jeff in the Palm Beach Gardens, and we're happy to try to arrange to do that as well. Because you're right, there's legislative changes annually. So we find that there's a real important need for us to get out and give that back. And obviously it's an opportunity for us to meet board members and managers who who have some familiarity with us, but to allow them to see what we could bring to the table should they desire to use us going forward.
Now, you also do a fair housing seminar.
We do.
When's your next Fair Housing Act seminar coming up?
There is the next Fair Housing in Pompano Beach will be Thursday, November 13th, and in Palm Beach County will be Thursday, November 20th.
Okay. And also, I think this was from last time, we had someone ask, what's the difference between assistance animal and a service animal?
Well, the service animal is a term that's used under the ADA, which Robert mentioned earlier, the Americans with Disabilities Act. An assistance animal is the term that is used for under the Fair Housing, the FHA, Fair Housing Act. And when we're talking about in the scope of community associations, residential community associations, we are discussing fair housing. ADA does not apply. And the reason that's, and I'll give you a couple of quick reasons why that's relevant. Service animals under ADA are dogs, and they have certification or training requirements. But under fair housing, which is what we're talking about primarily, they can be more than a dog. It could be a cat. It could even be a pot-bellied pig, miniature horse. And also, most importantly, there is no specific certification or training of that animal necessary. So that's a quick preview of the course, but that is what a service animal versus assistance animal.
Okay, so how prevalent are the assistant animal issues for community associations?
Well, if you opened the phones and offered everybody who has an assistance animal issue a few bucks, then you'd have 5,000 calls. We do this course in our Pompano office each month, and we do cap at about 50 people, and we have been we've had wait lists each month. It is a very it is an issue that is very prevalent. There is not an overwhelming amount of case law on it, but there's been a few cases recently which have been very pro, if you will, unit owner or requester, pro the requester. And the facts of those cases, to me, are self-evident that these are cases that should never have gone that far. There is an opportunity for an association to undertake a reasonable investigation, undertake their due diligence in ascertaining whether a request for an assistance animal is valid. But
with medical documentation,
right,
is that typically the case?
Yeah, there is medical, but there's that, yes, that's certainly part of it. But what's important is, and this is what we talk about more in the class, is it's what you ask for and how you ask for it that's very, very important, and how you respond when a request comes your way. I don't want to give too much of the class away.
Plus, the ramifications can be severe,
Very severe
if the association is found to have committed discriminatory acts in failing to follow these procedures. And there can be money fines involved.
Okay, we're going to take our last break, and when we come back, we have more with Kaye Bender Rembaum.
We'll be right back.
I could do this show, my eyes closed now. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
What our board op always gives us the finger. You ever notice that?
Actually, the good finger.
Yes, exactly. Hey, we're back live in studio. Our phone number here is 888-565-1470, and we're in our last quarter of the show. It's great to be able to watch the show live, but you can also go back at www.kbasandboyrlegal.com and watch today's show. There's so much great information on here, and we have two of the principals of the firm with us. We've got both Michael and Robert with us, and we want to get into what association refers a delinquent unit to the association's attorney for collections.
Right. As a matter of fact, somebody just called to ask, but they didn't want to come on live. So
were shy.
when, yeah. So when is it when somebody's delinquent? When is it time to hand that over to the attorneys?
It's important for an association to have a procedure in place and an understanding of their needs and their cash flow, and to have the procedure for collecting open and available to all the owners and known in advance. I have always counseled our clients that the longer you wait to start your collection process, the less likely you are to collect what's due to you. I think the majority of communities tend to be monthly in their assessments. There are those that are quarterly, there are even those that are annual, but the majority being monthly. And typically the governing documents will identify a grace period when things become delinquent and interest starts to kick in. There's also statutory issues involved as to the notification requirements that you have in the collection process that adds time to it. In condominiums, there's 2 30-day letters that have to go out before you can file a foreclosure case. And in a homeowner association, well, one's for the intent to lien, one is after you file the lien of your intent to foreclose if the owner doesn't pay or makes satisfactory payment arrangements. In the homeowners associations, these 2 letters are 45 days in duration. So for condominiums, you've got a 60-day wait in order to get to the foreclosure process to begin minimally, and in HOAs 90 days. So if the association's going to wait 3 months, 4 months, 5 months, and then have to tack on another 60 days or 90 days, that's going to make it that much more difficult. So generally speaking, if an association has a 30-day monthly assessment, by 45 days, that should be long enough that the association should be considering sending that to the attorney for the first 30-day notice or 45-day notice, depending on which it is. If it's quarterly, again, 30 days beyond the end of the quarter should be long enough. 45 days within the first month following the delinquency, giving them a whole month to become late, that's generally the ideal approach. Many communities, they realize that we're all homeowners here, but on the other side of the coin, we are also running a business, and the business needs these funds in order to operate.
Right. And piggybacking on that, it's not the first letter they get wouldn't be from our office. When you live in a community, you move into a community, you have an understanding. Even at closing, you know you have assessments that are due. So right away, you know you have an obligation.
Or monthly fees.
Well, that's right, the assessment. Right. Monthly assessment, quarterly, whatever it is, you know you have it. In addition to that, you likely get some kind of notification, coupon book, or the like from your board, or if you're managed from your management company. And if you're late, you likely get at least one notification that you're going to get you're late. So you have all these opportunities to address it before it even needs to move into the what we'll call legal arena, which is the collections, where we have to send that initial 30 or 45-day letter. But even if you don't respond, that first letter that we send, 30 or 45-day letter, gives you another whole window to wake up and say, oh, wait, I just got a letter from the law firm. I better address this now, because that first letter, for as far as your additional fees and costs, your interest to the association, your late fees to the association, plus the attorney's fees and costs, isn't that substantial. Hopefully your assessment, as Robert pointed out, won't be either if the board is looking at addressing these things more aggressively, say 45 days, because on a monthly assessment at 45 days, remember, you're already 2 months late. You haven't paid January or February.
Right. Some people, if they're foreclosing on their home, they stop paying that.
Well, and that's the other reason. If they've decided that they're not going to pay because the
If they're
bank
not
is
paying their
foreclosing on
mortgage,
their
right,
home,
exactly.
well, then you have an opportunity there to look at what's going on. You can see if there is a bank foreclosure. Again, this is where the case-by-case approach has to come in. But to answer your initial question is the board should set a policy. And whenever we're talking when a board makes that, the inquiry you gave us, when a board member makes that inquiry to us, our advice is it's a business decision based on what you know of your community, but in general, 45 to 60 days at most after the first payment is missed. So if you're due on January 1st, by the 15th of February, the end of February latest, you should be moving that file to your attorney for collections.
Okay. And what records should they maintain, the board members maintain, and for how long? What type of records should they maintain?
Well, Florida statutes are very specific as to the records that must be maintained by an association, condominium, cooperative, and HOA. and they run the gamut. They have to have a roster of the membership.
And a registered agent?
Well, a registered agent is, so everybody has, every corporation has to have a registered agent.
Okay.
But they have a roster of their homeowners or unit owners. There's financial records they maintain. They're to maintain contracts. You maintain bids. Most records are to be maintained for 7 years. Some records, like in a condominium setting, the election records are to be maintained for 1 year. In an HOA setting, it doesn't even express that they need to be maintained for 1 year. So some HOAs don't maintain their annual election records. But amendment, your governor, you have to maintain a complete set of your recorded governing documents, declaration, articles, bylaws. You should have a set of your rules and regulations, annual financial statements. Again, each of the Florida statutes have a specific list, and they have the catch-all at the end, all other documents that are related to the operation of the association. So it's pretty comprehensive.
But what's more important in the statute is what's excluded from the records that are available for inspection by any requesting owner. And these can get very involved and detailed. So the statute should be viewed from that perspective as well.
Here's one of the emails. Under the Fair Housing Act, do associations need to modify or provide an exception to its no pet rules or their policy? So I guess they're asking, how do they get their no pet rules modified? That's pretty hard to do, isn't it?
Well, the question under the Fair Housing Act, does an association have to modify their no pet? What you're doing when you have a request, for someone for an assistance animal, as we talked about, what they're asking for there is a reasonable accommodation to the no pet rule or restriction. Remember, under fair housing, assistance animals are not considered pets. So the fact that you have pet restrictions or pet prohibitions in your documents have no effect on the assistance animal. And so that has to be treated that way.
Okay, so, and this was, I guess, a follow-up about under what circumstances, if any, can an association deny a request for an assistance animal?
Under what circumstance, if any, can they deny a request? Well, I will tell you that I don't counsel our clients or anyone who comes to our seminars to ever say no.
Okay.
You don't automatically say yes, though. You have, like I mentioned earlier, there is the opportunity to undertake due diligence. If you say yes without looking at investigating further, obviously you're going to avoid any issue of fair housing or discrimination claim. However, and we've had instances where you have members of the community who are so opposed to having animals in the community that they're going to claim that the board hasn't met its fiduciary obligation if it hasn't undertaken its due diligence to ascertain this is a valid request. Okay. And so is there a situation where you can deny a request? It's going to be it's going to be very, very fact specific. There are cases though where they've denied requests, they've been lawsuits, and the associations have prevailed.
Wow, okay. You know what, before we get out of here, let's go over your seminars one more time.
Sure.
The 5th is in Tamarack.
Right. We have the Town Hall seminars, Tamarack. This is the first one, Wednesday, November 5th, 6:30 to 8:30 at the Tamarack Community Center on 8601 West Commercial Boulevard. And then December 10th, we have the Pompano Beach Town Hall from 9:30 to 11:30 at the Emma Lou Olson Center. RSVP to both of those, 954-776-1999, extension 255, or you can contact our office and we'll make sure we get your RSVP. We also have on Monday, November 10th, our joint seminar with Campbell Property Management on budget and foreclosure process. That's at the South County Civic Center in Delray Beach from 9 to 11 a.m., And then on November 18th, in our Pompano office, a joint course with Barry Scar of Scar Insurance on association operations and insurance issues. That's 6:30 to 8:30 p.m. You RSVP there directly to our Pompano office at Odalis at ODALIS@kbrlegal.com or 954-928-0680. All of those are free. Check our website for all information, kbrlegal.com.
Hey, I love having these guys on. Thanks so much for coming in today.
Our pleasure.
We will see you next month with another Ask the Experts. We'll be on also this Friday. Everybody have a wonderful week. Peace and love.
We're out.
Thank you.
Thanks for tuning in today to the Ask the Experts show with Steve-O and Renee. Tune in every Friday from 4 to 5 p.m. while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show. The opinions expressed on